Good afternoon. Brian Rosenblatt here with another SERMAPod. Today we have special guest Wallace Collins, an entertainment attorney out of New York. And we're going to be talking about, we're going to be using the Salt-N-Pepa lawsuit recently filed as kind of the framework, but we're getting into some technicalities and some issues within copyright law, specifically copyright termination and how do artists reclaim ownership of music. So first of all, Wallace, thank you for joining us today. We appreciate it. So Salt-N-Pepa sued Universal Music Group over ownership of master recordings. And I think where I want to start with this, if it's okay with you, is let's talk about the different types of copyright that exist in what we would consider a quote unquote song, essentially a composition and a master recording, and what's just the basically what's involved.
Right. Well, there's two copyrights when it comes to the music, basically. One is in the sound recording, which is the fixation of sound in a tangible medium. And the other one is, and basically the record business is built on that, records, the recording of the song, the music, the performance. And the other one is the song copyright, which is the words, the music, the melody. You know, the songwriters write a song. It may be the artist who does it too or co-writes it, and then they record it. So this copyright is the music publishing business. And this song is, here's what it is. It's a copyright. And then you can have multiple recordings of that song. So you can have cover songs. You could have different artists, that happens all the time, recording other people's songs. This copyright earns money from that sound recording, earning money, but there can be several of those. And so in the copyright law, each of those is covered separately. And one of which is, well, both of which are covered. And you want me to kind of explain what the law did that gives these reversion rights, or did you have?
Well, before we even talk about the reversion, let's talk about the act itself. Okay. Copyright attaches when we take a new or novel artistic expression and fix it in a tangible medium.
Correct.
That takes me an hour to explain that to a young developing artist. Generally speaking, under the Copyright Act, the creator of the work, that's what we call the artistic piece that's been created, the creator of the work is deemed the author and the owner of the copyright. That's the general default situation.
Right.
The exceptions are going to be if it is an employee doing work for their employer, or something called a work made for hire. So if you wouldn't mind, why don't you share with our listeners what that distinction is and what that actually means?
Okay. And the fixed in a tangible medium is, it sounds all highfalutin, but what it really means is when the songwriter writes it down or the recording artist records it, when you do something more than just say it. Hey, I'm thinking of doing a song about
when it's been captured in a way that is, when it's captured in a way that more than simply a thought.
Right, more than a thought or even speaking, it has to be recorded. So, or it was written down, recorded on a tape player, or recorded on your phone, or whatever. Some fixation in a tangible medium. So that's your expression of the idea, because the idea alone. And so then there's been a copyright law since 1909, but in 1976 they amended the law and they did several things. One of which was they extended how long a copyright will last for. I think now it's life of the author plus 70 years. Maybe it's up to 75. They keep extending it. But they also added a provision that said, provided, however, that certain works, after 35 years, the author or the author's heirs will have the right to terminate whatever transfer they did and get the rights back. And they divided it up. Pre-78 songs are 56 years from when you signed the deal or when they were released. 78 on, post-78 song, 1978 songs, it's 35 years from when you either signed the transfer or when the song was released. And so starting in somewhere in, I guess it was 90s. They started, that was 35 years after 1978, and you started having artists and songwriters want to terminate their copyrights. But there were certain exclusions from what you're allowed to terminate, and one of them was work for hire. So the copyright law generally says the author owns the copyright and can transfer it in a contract, but has to be a signed writing, so a contract. But a work for hire is a different kind of copyright where expected that the employer is hiring you to do it. So frequently, if they're hiring animation people in a Disney movie, it's work for hire. You're coming to our place. We're supervising you. We're giving you unemployment benefits. You're an employee for the purposes of this movie or this project. And it's this, and in any kind of business, if the employer sets it up that way, then the copyright law basically says the author is the person that contracted and signed you as a work for hire, meaning the record label, the movie company, whoever it is that's done that way. And as I will repeat, the songs are generally never work for hire. Maybe if McDonald's hired you to write a theme song or something like that, it might be work for hire. Sometimes a movie, the scores are sometimes work for hire. But generally, a songwriter writes a song, he owns the copyright, then he makes a deal with a publisher or some party to use or license that song for some period of time. So that's rarely work for hire. And when the songwriters have been terminating the contracts, there's been very little problem. The Willis case kind of involved that, but it was more the issue of, can one writer, when there were two or three writers, or co-writer, is one enough to terminate? And the case ultimately determined yes, because 50% is sufficient, right? One of two.
So just so our listeners are aware, Wallace and I were chatting beforehand about prior litigation involving copyright termination, and the case that he's referencing right now, Victor Willis. Victor Willis was the lead singer of the Village People. I think YMCA was the track. I think.
Right, I can't remember, but that sounds right.
It involved Scorpio Music. I remember that. All right, so let's talk a little bit about how this comes to pass, that there's a work made for hire agreement.
Right, okay.
You have we're dealing with. I'm sorry. Go ahead.
No, I was going to say it's a record company thing, right? So that's why it's coming up in this context. Right. Most record contract deals, I don't know why, but it is. When they make a contract with an artist, they say, look, we're going to advance you money. We're going to set up a recording fund. We're going to pay for everything, and then we'll give you a royalty on sales. It's a recoupable advance, but nonetheless, whatever we spend, we recoup out of your royalties if you earn. So we're taking the risk. But part of what we get is the sound recording is a work for hire made for us, Sony or Universal or Warner or whatever the label is. And it's just been the way they've done it for many, many years. There's usually belt and suspender language. I've done this for 35 years, so I know these deals. The language is slightly different in each, but it says the same thing. It'll frequently say, if it's determined it's not a work for hire, then you hereby assign us the right as the copyright anyway, so we have that. But the issue that's come up with the 76 law, when they made that 35-year and 56-year reversion provisions, I think it's section 203 and 302. They added in that language about, despite the life of the author plus 75, you or your heirs have the right to terminate sooner. This, provided you give a notice in a formal way, you serve it on the people, you give it to the copyright office, you pay a fee, you can do it. So a lot of artists have done it. But it's work for hire was an exclusion from that termination provision added to the copyright law. And so that's where the record labels tend to at least start out by denying your right to terminate it and claiming it's a work for hire.
Okay. So Salt-N-Pepa, they've had a few different members over the years, but the two original individuals, I think Cheryl James and Sandra Denton, that was before DJ Spinderella joined them.
Right.
They were signed to one of the Universal Music record labels. And they had their music. It was out for many, many years, the 80s, the 90s. And now they've hit that window where they're able to file determinations.
Right.
So what are they seeking? What are they trying to do and what's the purpose of reclaiming their copyright in the recordings?
Well, what? Well, because the label owns the master and probably pays them a royalty at this point. I'm sure they've recouped the advance, hopefully, and they're paying a royalty. But the royalty can be anywhere from 12 to 15, maybe higher. Depending, because a lot of those deals and their deal was made before digital existed. So a more modern way might be to split the digital 50-50, which is most of what the money is these days. But in the old days, that was, just a new technology. So you got a royalty rate. So you were maybe getting 15 to 18, maybe 20% for a bigger artist. Again, I don't know what their particular deal says, but so you're just getting a percentage of the royalties that Universal or Warner or Sony or any record label collects for the use of your music. And nowadays, when they say collect, all they're doing is having the DSPs, Spotify, Apple, whoever it is, pay them, right? So that's a very small amount of money because you're talking about fractional shares, and Apple Music takes a third, Spotify takes a third. So now you're talking about a small percentage of what your record label gets after the distributor, the the digital distributor takes a piece. So you're talking fractions of a penny and you're getting 15 or 18%. If you can terminate the right and get it back, now you own the master, and first of all, you can license it directly and get 100% of the money from a DSP. Because again, in the old days, you needed a label to print the product. You had to be in the studio. You had to then press vinyl or CDs. You had to store them in a warehouse. You had to ship them to a store in a truck and whatever else, right? You had to have store space. There were all kind of issues, right? Now you don't have that. It's all in the cloud. The DSPs just have all of the music in their database. And depending on what service, Apple, Spotify, whatever one you're with, you just access the music you want. But it costs the labels nothing. Right. So it would cost you, Salt-N-Pepa, if you can get your masters back, you can load them directly up. You can make your own deal with the DSP or even an intermediary like the Orchard or DistroKid or, one of the many, and upload it. You put the artwork up, put the music up, and now you're going to get 100% of that money. And you don't need the label anymore because that you don't need the printing and the shipping and the storage and the warehouse of the physical product. It's all digital. It doesn't make sense for a label to be allowed to keep those things, again, from a practical or a legal point of view. But their argument is because it's a work for hire exception, we don't have to give it back to you. And I think in this case, well, what mostly happens is with the big artists, going back to Prince and many others, Billy Joel did it, McCartney did it.
Bruce Springsteen.
Right. They renegotiate the deal. So Sony, whatever record label, we won't use names, just a record label, comes to the artist, whoever it is, and says, hey, look, fine. We dispute you. It's work for hire. We don't have to give it back to you. But how about this? We'll give it back to you, provided you agree to license it back to us. Hey, we're your record label. We've been working with you for decades. We know your catalog. We know where the music is out there. We know how to market it and promote it to your audience. You own it, but you license it back to us forever, right, or some long period of time, and we'll give you 80 or 90% of the money that comes in. Because again, we have no overhead, we have no packaging costs, we have no shipping. We the label don't have to do anything anymore. So we'll just take a small percentage, and we'll give you 90% of the money back, right? They're still making money as opposed to losing all the money. And again, there's no cost to that money anymore. So they're mostly happy to make that. And some artists will agree. The problem is some artists like Salt-N-Pepa. No, they don't. I represented Randy Bachman, and he's in the same position. He doesn't want them to have it. He's like, no, I want to have it because I can do what they can do and not even give them the 10%, right? So everybody knows who. They know Guess Who. They know BTO. I don't need them to tell anybody. My fans are going to speak. So, I represent him in several situations. So we're battling, right? With the label because same thing. It hasn't gone to a lawsuit yet, but we're going back and forth, and it could go there. But Salt-N-Pepa, I guess it got to the point where that was their final alternative: either give up and make a deal, or sue and try to get the court to order that you get your masters back.
So let me ask you this, because you raise a really an interesting question. And you referenced Randy Bachman. I'm just going to talk about it generically,
Right.
but for the artist that says, I don't need the label to do this anymore, I can do it on my own.
Right.
The question that I've got is, can they? Can they really? I mean, technically, sure, but aren't there a host of other label services that you want? The affinity with a record label, the marketing department, the push, the inclusion on label sponsored tours with other artists that kind of help perpetuate their record sales.
Yes, although I think that's less. If you mentioned like a Springsteen and with Billy Joel, Paul McCartney, the real
Well, that's
superstars,
that's the
less and
stratospheric
less.
artist that doesn't need anybody's
Right.
help.
They're going to have, right. They already, everyone, the people know who they are. They put their music out. And again, when I say the artist is going to do it, obviously the artist has a team of business people, staff that will actually do it. He'll just get the rights back and say, okay, guys, put it up on the DSPs and they'll all be happy to have it because they make money too, right? Spotify and Apple, they're all making money. So that goes, fine, let's make a deal with Billy Joel or Paul McCartney. Put it up. And they really don't need anybody to help them market and promote that much unless they're putting out a new record. But again, you could probably hire an independent company to do that, right? So for those level people, then I think you get middle level, and it's not meant to be pejorative in any way. I'm just saying, the people that aren't, like you said, those marquee superstars, the Salt and
Right.
Pepper, and others, where they decide to strike the fight. And yeah, but there may be benefits. But again, maybe you can hire a lot of legal label services, label services to help you out anyway. Again, I don't want to go down that rabbit hole, but I think, if Salt and Pepper got their stuff back, and they're probably not making new records, right? A lot of these artists are not making new records. So
They'll
it's really
show up
all
as a
about the old
feature.
catalog.
They'll show up as a feature on somebody
Right.
else's project once in a while, kind of thing, a lark, whatever it is. But nobody's
Right.
buying new music from Salt and Pepper. I agree with you.
Right. Or a lot of artists. Like I said, they're living off their catalog and touring and whatever else, but if they could get their catalog back, their masters, they could make a lot more money from the little bit of money that digital streaming is paying, right? Like you rather get 90 or 100% of it than, 20 or 15 or whatever their royalty rate is, right?
I would I would imagine that when Salt and Pepper get just a little bit older, a little bit further down the road, they'll be looking at doing what Robbie Robertson, Elton John, Bruce Springsteen, Billy Joel have all been doing, and that is selling their catalogs.
Well, that
Um,
that too, right? That's
so
another.
that provides that extra set of rights that they actually have it that they can sell it then.
Right, correct.
Let me
And
let me
that's
ask
a big issue.
let me ask you this question, because as you know, I get the pleasure of doing the transactions, but I also am a litigator at heart. Um, what what leverage does Salt and Pepper have if they own the compositions, right? If they were the actual
Right.
songwriters and they own that, do they have leverage in this process by telling Universal, okay, if you're not going to give me back the actual records, then you no longer have a license to use our compositions?
The problem is probably when they granted it, they granted a mechanical license, for the life in the song to the life of the sound recording going. And you also have compulsory license issues. But the other part of the copyright reversion said that when you get the reversion, it's kind of from the day of reversion forward. You can't go back, for instance, and tell them you have to take it off any compilation record you license it to. You have to take it out of that movie you licensed to. So any prior license and agreements, including a mechanical license, continues, right? So you can't stop them from using the record with the song in it. It's just that you don't have a publisher taking a piece anymore. All the 100% of the money from it, from the record label mechanical royalties and the PRO performance royalties, will come to you as a songwriter now. So that's the benefit. I don't know how much leverage you could really use it on the other side. The leverage is, and I'll mention this case because this is a big deal. I used it once years ago, in a not officially a formal major record label case, and it ended up in a New Jersey federal case decision. But it's called Community for Creative Nonviolence versus Reed, REID. And it went all the way to the Supreme Court where they laid out, well,
That's the
look,
Living Color case, right?
no,
That's Vernon
it was
Reed.
Community of Creative Nonviolence. I'm not
Vernon
sure, to
Reed from
be
Living
honest.
Color.
Okay, maybe, I'm not
Yeah.
sure, but I
Yeah.
know
No,
that
sorry. Go ahead. I didn't mean to interrupt. Go ahead. Go
it's
ahead.
fine. The thing that case did was that they went through a list of factors. They said, all right, if we're going to determine whether something was a work for hire or not, we need certain factors. One of them is that you have something written in the agreement with the employee. Okay, well, the record label's contract says you work for hire. But everything else that would make you an employee is not that, right? An artist had to do with like you're going to record under our supervision and our direction of the employer, right? You're going to get unemployment benefits. You're going to do it on the premises, or we're going to supervise you wherever you're doing it. There's a whole, and what an employee would be in a company, right? And basically, if you apply any of those factors to a record contract, no, the only one they have is if we say work for hire. They're not paying unemployment benefits. God knows they're not supervising McCartney or even Salt-N-Pepa. They give them a budget, and Salt-N-Pepa goes to the studio and does what they want and delivers a finished product. And they're probably not doing it on the premises because years ago, record labels, although they did have studios, they got rid of them all. So all the things that they might have done to argue it's a work for hire, all they have is the contract. They don't pay unemployment benefits. They don't treat, you don't punch in, right? It's not, you're
Well, they're
not a
not.
work for hire, really.
They're not paying the health benefits. They're not. They don't have
Okay.
withholding taxes.
Right.
Which,
None of
in
that.
theory, wouldn't that be interesting? Because I know Victor Willis actually with the YMCA case, he actually raised that as a series of arguments that if you really think that I am your employee, where is my back pay for the past 15
Right.
years? Where's
Unemployment
the value?
benefits. Right.
Yeah,
Exactly.
which
Right.
I
FICA tax, all the stuff you should have been paying if I was an employee. But the labels don't want that. First of all, they don't want to pay those things. And second of all, yeah, they just, I'm paying you money, just record the record. And they don't want to interfere with a McCartney or a Billy Joel or any of those people. They know Springsteen. Can you imagine? I mean, I'm sure the A&R guys go to the label, go to the studio sometimes and check out what's going on. Maybe more so with a middle level artist to see how our money's being spent. Salt-N-Pepa's been in the studio for 8
right.
months. We better see what's going on there. But other than that, they're not really supervising. They're not an employer in the sense of the cases. That's the main case.
No,
My case was called
they're gonna be
Dallas.
interested. They're gonna be interested in what you're putting together, so that
Right.
we know how to funnel it into our marketing channels.
Right, right.
That
But it's really
exactly
you're an independent contractor and you're not an employee. In fact, usually there's language in the contract elsewhere that says, for the avoidance of that, we're not partners, you're not an employee, you're an independent contractor. So in a litigation, there would really be a battle. And the danger would be if some case, whether it's Salt-N-Pepa or somebody else, got all the way and the court determined, and then on appeal, and it went to the Supreme Court, and they applied these, factors, the Reed factors, then they would say, sorry, record labels, sound recordings are not a work for hire under these deals. And that would set, in effect, a precedent, and you'd have opened the floodgates because every artist will say, well, if it wasn't for them, then it isn't for me because I'm also signed to Sony or Universal or Warner or Columbia or Epic or whatever label, and I have the same basic work for hire provision that they have. So if theirs isn't valid, mine isn't valid, which then is the reason why the labels almost 100% of the time have settled the case. And we'll see
that's
what
the
happens
artist.
here.
That's the artist leverage point right there. Is the
Right.
labels
They don't
cannot
want
afford to allow the floodgates to be opened.
it. Right. They don't want the court to decide. Yeah.
What departing advice would you give us before we wrap up, or give artists on how to better protect themselves with record deals?
Well, again, the whole Taylor Swift thing that happened recently where someone sold her catalog and then she finally, her in her position, not only started re-recording all the records that got transferred, but then turning around and bought them back from Scooter Braun or whatever hedge fund owned them at the time. Kind of at least sent a wake-up call to a lot of artists to realize that maybe they don't want to do it that way. And again, labels in the old days when they were required to, print the record, store the record, warehouse it, ship it to the store, do all that kind of stuff, you needed them more. Now I think with the leverage that the labels have a more difficult time even marketing and promoting artists from scratch. It's easier to take a hit or a big artist and keep getting them out there. But there's many fewer breaking artists these days breaking through because you have so many thousands of artists putting out their own music. I think the leverage is at the contract stage, and I've done a few of these where we might say, we're either assigning to copyright them for 10 years or 15 years, a limited amount of time, rather than work for hire, or even saying we're licensing the masters to you, again, 15, 20 years, long enough for the label to have a good situation, shorter than the 35-year, copyright law termination. But again, at the negotiation stage, that's the best possible time to try to get rid of the work for hire concept and say, I own the masters. I'm assigning them to you for 10 or 20 years, or I'm licensing them for 20 years. And at the end of that time, they come back to me under certain conditions. Maybe we have to be recouped, under the record label. There might be some conditions, but again, a lot of this has been done, but only in the very newest deals. Because I think at the end of the day, the labels realize it's an endless fight. And by the time these songs come up in 35 years, the law may be different just because of the case law. Like I said, if a Salt-N-Pepa, and this is what it would take someone like a Salt-N-Pepa to say, I don't care, I want them back, and I'll fight all the way till the end and run the risk that the court will say yes or no, which is a much bigger risk for the label than it is for the artist, probably, right? I mean, if they're willing to lose it all. And that's years and years and years ago in England, that's what Gilbert O'Sullivan did, the song Alone Again Naturally. He was in a lawsuit with his manager / production company, who was also his record label, and in his lawsuit, he won all of his rights back. And hey, but he was one of those guys who was willing to go all the way, right? And then several decades later, he was the one who kind of set his songs, his rights, triggered the first thou shalt not steal decision from a New York federal court on sampling. Because I think Bismarcky had sampled Alone Again Naturally, and the concept at the time was, everybody always agrees, we'll make a deal, we'll license it, just notify them and we'll make a deal. And having gone through what he went through, the story was that Gilbert O'Sullivan was living on an island somewhere, and he said, no way, no one touches my stuff ever again, right? And so they were dealing with the wrong guy, right? He's not a guy you should have sampled without asking first, because the answer was no. He told you no. You figured, everybody agrees, his label will agree, because the big majors would, I'll give it to you if you give it to me. I'll give you Puffy, but you'll give me Sting, and da-da-da-da, right? But now you're dealing with an outsider, and the outsider says, no, I don't care. And he sued, and he went into federal court, and the judge said, look, I know you guys all think sampling is fine in your business, and that's up to you, but that's a contractual thing. According to the copyright law, what you did was you stole his music. And the number one rule, even above copyright law, is thou shalt not steal. It was kind of a funny decision. And he went off to say, you can't do it. So since then, I think it was in the 90s at some point, sampling became a whole business where contracts and, you had sample clearance companies and all this stuff. So it went from an outsider who said, I'm going to fight to the end to get his masters back. And then 20 years later, when someone sampled them, he fought. Again, you take somebody who says, I don't care, I'm not making a deal, the law is on my side and I will get what I want. And if you've got the wherewithal to fight a major label, because you also have the money, there's an issue, then you can potentially do it. So a Salt-N-Pepa or any given artist who doesn't make a deal with their label and says, no, the end game is I want my masters back and I don't care, potentially could set a precedent for everyone else. Again, there's always 50-50. You can go against them and the court could say otherwise. But based on that Community for Creative Nonviolence decision that was out there 20-something years ago and still is kind of the precedent listing the factors that have to be, as we discussed, employee and employee benefits are paid, and you're working on site, and you're supervised by the employer. None of that applies to almost any recording artist in the real world. So I think, again, if you can do it initially in your paperwork when you make the deal, that's the best way. But if not, then I think you kind of hope or root for these other artists to get a precedent so that by the time you're giving your notice, you can get your rights back.
There it is. All right.
There it is. All right.
Well, thank you very much for joining us, Wallace. Hang on for just a minute. This has been another SERMAPod. Brian Rosenblatt. I'm general counsel and an advisory board member for SERMA. Join us in a couple of weeks. We'll have another podcast up and ready to go. You can always find more information about SERMA at www.theserma.org. If you have questions, issues, let us know. And if you have additional topics or anything that you'd like to chat about, or if you'd like to be a part of one of our podcasts, reach out. Let us know. Happy to talk to you. Thank you.
And my website, just so you have it, is
yes.
www. Right. I mean, you could Google my name and you'll find me, but it's www.wallacecollins.com. But if you just Google Wallace Collins, it pops up because I've written articles and I've spoken and things. And so there's a lot of things that'll come up if you need to find me. And if anyone has a question and you listen to this podcast, email me and just say, hey, I listened to the podcast, but I have a question. I'm happy to answer it as part of, supporting the SERMA, the whole project.
That's generous of you. Thank you very much.
Okay.
Thank you. Have a great day.